Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, today's discussion is on Commercial Court Acts. And just to give you a brief introduction about the Act, that the Commercial Courts, Commercial Division, Commercial Appellate Division of High Court Act was enacted in the year 2015. Subsequently, there was an amendment that happened in 2018. The main purpose of this act was to create a specialized ecosystem for the purpose of adjudication of disputes with respect to commercial disputes of a specific value. And obviously, the aim and objective of the act was not just to create a positive image and to improve the international image when it comes to the justice delivery system, because in regular course, you have civil trials going on for years and years and taking a long time for resolution of disputes. So this act was brought into the scene. And another reason being that it is also a laudable piece of legislation, and it's also a step in the right direction. And because the spirit behind the amendments that were made to CPC are also laudable for that purposes. So today we have with us to elaborate further and to give his insight a very eloquent and an articulate lawyer, Mr. Shashank Agarwal. He joins us. Thank you so much, Mr. Agarwal, for your time and sparing out time from a busy schedule on a working day. Mr. Agarwal holds a BL LLB in International Trade Honors from NLU Jodhpur, National University of Jodhpur. He also holds a certification in cyber laws from the CILI New Delhi. He is also holding an advanced certification in Companies Act 2013 from NUJS, Kolkata. He holds in distinction of being the first senior vice president of Rajasthan High Court Bar Association from a 5-year law course. And currently, he's also the president of NLU Jodhpur Alumni Association. He also is a trustee of the Satish Chandra Agarwal Memorial Charitable Trust. And apart from that, post-graduation, he joined the eminent chambers of Sri Sudhanshu Kasriwal, learned senior advocate. Subsequently, he worked in the esteemed chambers of Justice Ashok Kumar Gaud, who was then senior advocate from the year 2011 to 2013. He got independent in 2013, where he started his own chamber practice and appeared frequently before Honorable Rajasthan High Court, Jaipur Bench, Sessions Court, JDA Tribunal, Commercial Court, Consumer Courts, Family Courts, NCLT, and other forums. He continues to do title searches for big corporate houses and firms, and he's also presenting big clients like Indigo, Asian Paints, etc. And he's also on panel of legal aid, and has also been appointed as chairman in amalgamation proceedings before Rajasthan High Court. Appointed as amicus on a number of occasions by Honorable Rajasthan High Court, and has been invited in numerous moot court competitions to judge before various NLUs like NLU Jodhpur, Amity Law School, etc. So these are some of the achievements that, owing to the paucity of time, we could take out from Mr. Agarwal. So thank you so much, Mr. Agarwal, for joining us. And the stage is set. The floor is all yours. Over to you.
Thank you, Jay. Thank you for inviting me and giving this opportunity to be a part of your virtual amicus. And it's a pleasure and it's a great opportunity for us to be a part of this venture where we can share our knowledge and gain knowledge from all the presentations which are available on the platform, the virtual amicus. Now, today we are going to have a talk about the Commercial Courts and Commercial Court Act. So before exactly going into the specific provisions of Commercial Court Acts, let us first discuss and know how this Commercial Court Act came into existence and what was the need for the legislature to come up with a separate act to deal with commercial transactions. So it was in 2003 for the first time when the Law Commission report suggested for a specific commercial division in high courts. Now, the need for having such a division or a separate commercial division was because it not only brings an ease to settle and decide the commercial disputes, but also helps in bringing foreign investment and encouraging domestic transactions, domestic businesses also. Because as we all know that there was a time when it was a general phenomenon, it was a general image of the judiciary system, the judicial system, that the cases take decades to get decided, and by the time that these cases were decided, the organizations or the companies or the people involved were no longer associated with it or no longer into existence. And then finally, when the justice was delivered, there was no one to actually enjoy that justice. So when Law Commission first recommended to establish commercial division in the High Courts, it was pondered upon, and gradually in 2009, for the first time, the bill to establish such an act was presented, which was then again discussed and argued upon, and certain amendments were proposed. And in 2010, again it was put forth in the Rajya Sabha, and then subsequently and finally in 2015, this bill, the bill which was presented in 2015, came into existence. Now, this act came into existence on 23rd October 2015, and it is very fortunate that in 2019, on 31st October 2019, it also extends to J&K. So now, coming to Commercial Court Act, now to examine the effectiveness of any legislature, there are three things which we need to discuss and self assess ourselves also. First is basically whether the objectives are precise and or lucid or both. Secondly, whether they are simplified and unambiguous enough in promoting the objective of the act. And thirdly, the conducive implementation of the act. Now, as even Jay gave us a certain introduction why this act was enacted and what was the need. It was basically enacted for commercial transactions which are being executed and done in our nation, India. Could be, if there is a dispute in those, they could be decided and could be if settled maybe by mediation or by any modes as soon as possible, and not after decades and decades. Hence, the definition of commercial dispute, which is stated in the Act, covers n number of transactions, which is quite exhaustive. It covers transactions from tender related to JVs, to partnership agreements, to IPRs, franchising, and even relates to immovable property used exclusively in trade or commerce. And in the explanation given the definition, commercial disputes which are against state or are also covered with this. The major area which is not covered under commercial disputes is basically tax related issues. Other than that, the definition of a commercial dispute is quite exhaustive and also leaves some room to incorporate certain transactions which are of commercial nature but have not been defined specifically in that definition. This helps because the definition being exhaustive. This helps the legislature, and it is quite appreciable that there is a scope to incorporate other transactions also, which the legislature could not foresee at the time of implementing this act or drafting the bill, because the final objective is to do better commercial transactions and bring in more foreign investment by doing justice to the party agreed in commercial transactions. Now, initially, when this act was enacted, the subject value or the peculiar jurisdiction of the commercial courts were decided to be of 1 crore, which for certain states and for certain cities was quite a big amount. So later on in 2018, on 3rd May 2018, this amount from 1 crore was amended to 3 lakhs. Now, when we look at it, whether this amendment or this reduction from 1 crore to 3 lakhs, was it justified? Was it beneficial? Or was it, and actually it became a hurdle in implementation of Commercial Court Act? This, in my opinion, would not be a hurdle, but rather it would be a beneficial amendment, as 3 lakh rupees covers not only big transactions, but those small traders and small businessmen who are based out of small cities and have just begun to contribute to the Make in India project, or the concept of ease of doing business in India, which the governments are actually projecting. So if they are also included in this act and their disputes are also settled under Commercial Court Act, I feel that they would be encouraged to do more commercial deals and commercial transactions, because there was a time when foreign investors were quite apprehensive to come to India and invest because of the lengthy judicial proceedings. But because of the new act, there is a high possibility that these lengthy proceedings would be time bound or would be decided in fairly reasonable time period. Now, there is a very interesting provision in Commercial Code Act with respect to jurisdiction of Commercial Code. Under Section 12 of Commercial Code Act, it specifically states that there would be no appeal or revision which would lie against the order passed by the Commercial Code Act with respect to the jurisdiction of Commercial Code Act. Now, this provision, in my opinion, really helps in curbing a lot of litigation, because a lot of litigation sometimes are out of the jurisdiction issues only. And because of that, for years and years, the matter is not heard on merits, and just on this technical issue, matter goes from one court to another, and the issue of jurisdiction is either decided after tens of years, or whenever it is decided, the actual merits of the case are lost in that process. Now, how the commercial code acts, or what is the now let us discuss what is the actual procedure which is prescribed in Commercial Code Act. It is not very different from this civil suit proceeding which is already provided in CPC, or or the daily session code, or the suits which we handle every day in session code. But there is a big and vast difference when it comes to Commercial Code, because there is a lot of timeline which has been provided. If we follow that, and if the courts follow that, all the disputes can be decided within a span of 1.5 to 2 years. You'll be surprised when I tell you the timelines for each and everything. There is a timeline which is provided under Commercial Code Act, which is not known to many. Because as this is a new act and the courts are new, the judges who've been appointed in these courts are new, as transfers keep taking place, and the entire procedure of Commercial Code Act is a very niche and very specific procedure. People are not actually aware of the intricate details of the act. Now, before filing any commercial code dispute, one needs to file for mediation, that is pre-institution mediation settlement, which is provided under Section 12A, and the under the said section only, it is provided that this mediation and settlement would be dealt by the legal services, would be dealt under Legal Services Authorities Act. So that means the people who will be sitting for mediation and settlement would be trained mediators, and would help in solving and settling the dispute before it actually goes in the court. Now, the timeline to have a settlement is 3 months, and it can be extended for a further period of 2 months with the consent of the parties. And if there is a settlement, that settlement would be as good as an award passed under the Arbitration Act. Hence, even if the settlement takes place before the suit is filed, or before the suit is filed, Commercial Code Act, the parties can have an award in their hands by agreeing to the terms under Section 12A of Pre-Institution Mediation and Settlement. Now, further, this period when the settlement proceedings go on, they are not covered under the limitation period. And if there is an urgency, this period of pre-litigation can be excluded by filing an application that there is an urgency, and the courts will hear the parties before actually forcing them to go for settlement before filing the suit. Now, after the suit is filed, there are various provisions which need to be followed. Once notices are issued, then the defendant has to file the reply within 30 days, and if they want extension, with the permission of the court, and by paying cost as deemed appropriate by the court, this timeline can be extended to 120 days from the date of receiving the summons. However, as we know practically, in some of the cities or states, this timeline is not followed very rigidly and very rigid. Because of that, again, the delay keeps happening. Now, once this reply is filed or these 120 days expire, the right to file reply by the defendant automatically ceases, and the court can ask cannot grant any time further to the defendant to file reply. After that, both the parties are required to do inspection of the documents and everything which the parties have filed, and that has to be done within 30 days of filing of the reply. Once the inspection is done, then they have to file an affidavit of admission and denial. I will come back to all these issues in detail, how it is to be done, but I'm just giving you a crux of the procedure which is to be followed in commercial code. So after you file, after the inspection is done, the parties are supposed to file admission and denial affidavits within 15 days of inspection. In these affidavits of admission and denial, they are supposed to basically either accept, deny the contents, the correctness, the execution, the receipt of the documents. Once it is done, the court has the right to adopt the case management system, wherein the entire proceedings will be concluded within 6 months, and the first hearing under this case management system has to happen within 4 weeks from the day these affidavits of admission and denial are filed. Under these admission and denial, under this case management system, once the dates are fixed, the courts have all the powers to determine the dates for cross-examination, for filing evidence, for deciding a preliminary issue, or which issue will be decided at a later stage, or what is the extent of the evidence which needs to be filed, what cross-examination can be done on a daily basis. The courts even have the power to actually redact or dismiss part of the affidavits if they feel that these affidavits or the evidence which is being filed is basically taking time of the court, and they are all vexatious or unnecessary, or do not pertain to the main issues of the dispute. Now, once these dates are decided, so a total of 6 months time is provided for that. And then again, for filing written arguments, for filing written arguments, the court has to give at least 4 weeks time. That is basically prior to the final arguments happen. So once and after the final arguments happen, the court can grant another week's time to the parties to find their amended written arguments. It is a point to be noted here that in the act itself, they have specifically mentioned how the written arguments are to be filed. All the case laws need to be filed along with it. The sections, the acts which we are relying upon, specific documents or pleadings which we rely upon need to be mentioned in those written arguments. And finally, the court has to pass the judgment within 90 days from hearing the final arguments. So if you actually calculate the timeline, you will find that even after taking extension of time, which is provided in this, the entire case can be decided within a span of 2 years. 2 years. So this shows that this act has actually made an effort, to curb the timeline, curb the time period for adjudicating these commercial disputes, which have a major role to play in deciding the investment, the commercial transactions, the ease of doing business in this nation, and have a very large impact on an international and global scale. Now, after that, I would also like to bring your notice to certain provisions of the act. For example, the appeal which has to be filed within 60 days of passing of the order, and they are to be decided preferably within 6 months, or even all arbitration matters are part of this commercial code. So the objections, the execution petitions, everything, they are to be decided by the commercial courts. Now, under under this Commercial Code Act, there are certain provisions of CPC which have been amended and they specifically apply only for commercial code disputes. Once you go through these amendments, you will find that the certain procedures have been made elaborative, have been made simpler, or have been made for the benefit of the parties, for the benefit of parties in the sense that they can actually practically implement those amendments. For example, one of the biggest amendment, in my opinion, which is that in commercial code, you are not required to file the original documents against the suits which are pending before civil courts. Now, this is a major amendment in my opinion, because sometimes filing original documents is a hurdle for certain parties, because the original documents of corporates are not with the local office, or they need to take permission to get transferred from head offices and all those things. So when you have a specific timeline, these kind of hurdles are totally avoided by provisions like these, that the original documents are not required to be filed. Even when it comes to interrogatories, which can be filed, interrogatories are basically certain questions which can be filed by one party, to the other, and the other party is required to give answers to those queries. It is sort of a written cross-examination, but the court can examine and decide whether these questions are to be answered, and if the other party doesn't answer properly, they can direct them to actually answer them, and based on that, the verbal cross-examination, whenever it happens, can happen maybe more exhaustively or maybe more precisely. So these are the kind of amendments which have taken place in CPC with respect to commercial disputes, even to the extent that the costs which can be imposed, which by the court has been discussed in detail in commercial code, to what extent can they actually put cost on the parties, which is very appreciable, as they themselves use the word exorbitant cost in the act itself, which means that the court has the power to impose exorbitant cost on the parties. They feel that they are resorting to such activities or such practices, which is delaying the justice delivery system. Now, other than that, there are certain other amendments also, which are there in the Commercial Code Act. For example, how the admission and denial needs to be done. So when the admission and denial of documents are done in the manner as prescribed in the Commercial Code Act, if the other party admits the contents, the execution, the parties to it, the receipt of it, or a delivery of it, then there is no scope of doing any cross examination, as the other parties already admitted to all the aspects of the document. So all these things which need to be followed actually create a simpler process for the commercial courts. Now, there is another very the system of summary judgment, which is there in Order 12, Rule 6 of CPC, but in Commercial Court Act by way of Order 13A, the process of summary judgment has been introduced and implemented in the Act, which basically states that before framing of issues, either of the party can file an application for summary judgment. That is, basically, the party states that the other party has no scope of winning the case or defending their cause, or has no substantial defense because of certain things, and all the aspects which they rely upon, whether it is the documents or the pleadings or any other document which they have already filed, can be filed along with that application of summary judgment. And for filing summary judgment application, there is a fixed period, that before framing of issues it has to be filed. Then within a fixed period, that is within 1 month, the opposite party needs to file reply, and if the plaintiff or the party who was filed for summary judgment needs to file a rejoinder to that, they have 7 days to file that. So the timeline has been given for each and everything in this act which was not there in CPC per se. Hence, it becomes quite it becomes quite reasonable to say that this act has actually made an attempt in making sure that if this act is followed to the T, the disposal of cases and the disposal of cases would be much faster. The parties would be subjected to less stress, and even the advocates would be free from the litigation within a very reasonable time and can move on for another case. And but the judges and everybody involved in these kind of litigations need to be given that leverage and training to explore and actually implement this act. As this act is in nascent stage, it is just 5 years, as last 1 year was not actually litigation period as such. So I can say it was approximately 5 years since this act has come into force, and we have not seen so many judgments coming out of each and every state. Maybe few of the states are giving many judgments, though they are supposed to put their data online in terms of the number of cases filed, number of cases adjudged, number of cases decided, disposed of, dismissed of, all those things. They need to put it online, and the state government has been given the discretion and the authority to actually give infrastructure for commercial court and to have a separate building for commercial courts. The actual reason for giving this authority and doing certain acts and giving that authority and leverage to the state government was basically so that state-of-the-art infrastructure could be developed, cross-examination could be done through video conferencing, all the computer systems and all the systems which are required to do the proceedings through virtual communication could be done if required. And surprisingly and sadly, in some of the states, though the high courts and Supreme Court and various other courts were functioning through virtual conference, there were many commercial courts which did not have a proper virtual room or a virtual way of adjudicating the matters. Not even one matter was adjudicated through virtual mode in some of the commercial courts. So, though the legislature has come forward and actually given the judiciary and judicial system to actually make some effort and progress in a way that we can actually become part of a new era of the judicial system. However, due to certain reasons or certain reasons and basically certain lacuna on our part, we are not able to actually achieve what this act is trying to achieve, because the results of this act, the results of the cases, the timelines if followed properly would have a far-reaching effect and would impact our investment in the nation on a global and international level, which many are not able to foresee. So at the end, I would just like to give a brief of what I've actually said, that if the timelines are followed, the entire dispute can be decided maybe within a span of 2 years, which is a very reasonable period for any judicial system to decide big commercial disputes. Also, there are provisions in this act which help the parties to come to a settlement, and there are provisions in this act which give the authority to the governments to provide the state-of-the-art infrastructures so that all kinds of commercial disputes can be dealt with. However, there are certain lacuna, there are certain opinions that because the pecuniary jurisdiction has been fixed at 3 lakhs and only the central government can change this jurisdiction by way of notification, hampers the entire objective of the Commercial Act, because it raises the number of cases drastically, because from 1 crore, reducing from 1 crore to 3 lakhs, increases the number of cases in commercial court drastically. And because of that, the burden on the commercial courts would be way higher than what was actually expected. So the answer to those those objections or opinions is basically the state government should have the authority to decide the pecuniary jurisdiction, because they know best what is the jurisdiction which can be decided for such disputes. And secondly, if more judges are appointed, then this opinion or this problem of having too many number of cases in one court would definitely be solved. Hence, in my opinion, altogether, Commercial Court Act is basically an act which will go down in the history as one of the acts which has actually tried to bring in massive changes in the entire judicial system, in the judicial process, and also an attempt to increase the investment and the entire business transactions and faith in business transactions to a very large extent. I hope this talk of mine was useful to you, and you must have gained, and I'm really hopeful that you would gain certain points which would be helpful in your litigation as parties or as counsels. And I wish you best of luck. And once again, I thank Jay Loda for giving me this opportunity to be part of the virtual amicus, and I'm very grateful to him. Thank you. Namaste.
Thank you so much, Mr. Agarwal. You very rightly pointed out towards the end of your presentation that the objective of the Act can only be achieved when we have a sufficient number of commercial courts that are set up in all districts by the states, within a very short span of time. We also need adequate number of judges. For that purpose, we need an appropriate infrastructure. We need a lot of perks so that we can attract more trained and competent people who are selected on the basis of merit as judges of commercial courts, so as to achieve the purposes that is there in the Act. That the reason why this Act was brought into force, and it is indeed a landmark legislation. So thank you so much. I hope the words of wisdom that were coming in from Mr. Shashank Agarwal will immensely benefit all our viewers. And if you still have any query on any of the fundamentals or concepts, feel free to write to us. We'll be more than happy to forward the same to our keynote speaker, to our amicus for today's session, Mr. Shashank Agarwal, to assist you on that very query. You can directly write to him as well, whatever works for you, whatever suits you. So thank you, Mr. Shashank Agarwal, once again for taking out time on a busy working day and taking out time from your busy schedule. Thank you so much, everybody, for your patient viewing. And stay tuned. The next episode is on its way. And please stay home. Please stay indoors. Please like, subscribe, and share my channel. And venture out only if it's very essential. Thank you so much once again. Thank you.